So we have some big news in the Supreme Court. An emergency application has now been filed to the Supreme Court for them to step in right here and now and issue an injunction which would temporarily block Illinois' rifle and magazine ban. So we need to talk about what's happening in this case and what are the potentials. But real quick before we jump into this video, I want to thank the sponsor of this video, which is American Hartford Gold. If there's one thing that those of us in the firearms and Second Amendment community know and understand, it's that you cannot rely on the government for protection, not with your life and not with your wealth either. As we face unprecedented inflation, it's becoming increasingly important to shield your savings. Banks are going to be having issues left and right. We've seen a lot of things change, interest rates, inflation. And so one of the things that you want to protect yourself with is potentially some precious metals. If you would like to start investing in precious metals or protecting your wealth of precious metals, I cannot recommend American Hartford Gold enough. They have thousands of 5-star ratings and A+ from the Better Business Bureau. And if you tell them that I sent you, they'll give you up to $5,000 in free silver on your first order. So if you're interested, call them now, or you can click the link down below in the description. You can call them using the number 866-338-3915. That's 866-338-3915, or text ARMED to 65532. As I mentioned in the intro, I have an important update for you on the current issues surrounding the state of Illinois' rifle and magazine ban. An emergency application has now been filed to the Supreme Court, and the Supreme Court has requested further briefing on whether or not they should step in right here and now on an emergency basis and halt this law. The case we're going to be talking about in this video is Nagr versus the city of Naperville. And this case is a challenge to the city ordinance, which bans rifles and standard capacity magazines. This lawsuit is also important because it challenges the state of Illinois' Protect Illinois Communities Act, or the PICT Act, which bans rifles and magazines statewide. This case has once again been submitted to the Supreme Court on an emergency basis, and the Supreme Court has the ability to grant immediate emergency review on these issues. The biggest concern is that this law in question, the PICT Act, has a rifle registration deadline that is currently set to terminate, and it's going to terminate at the first of next year. So there is a significant looming deadline, which has now resulted in Nagr having to file an emergency intervention, seek emergency application for the Supreme Court, and have the Supreme Court step in at least until the 7th Circuit reviews this case en banc and issues their decision. Now, for those not aware, this all involves an important challenge to the Illinois ban on so-called assault weapons, their rifle ban, and also their standard capacity magazine ban. In this Nagr case, the plaintiffs originally filed a motion for preliminary injunction at the district court level. This is a federal case. A preliminary injunction is a way to temporarily halt the enforcement of a law. So that is what Nagr wanted. They wanted at least a temporary halt on the application of the city ordinance and then also the state law. However, on review, that federal district court denied the plaintiffs Nagr's motion for a preliminary injunction. Then Nagr decided to appeal that district court decision, that denial, up to the 7th Circuit Court of Appeals, and it went in front of a 3-judge panel. Now, this is specific because this is what's known as an interlocutory appeal. It's not an appeal on the full merits of a case. Instead, it's an appeal on that in-between denial of that injunction. It's essentially an appeal on a motion being denied rather than an appeal on the final resolution of a case. Now, here's where this case is significant and where things kind of get a little convoluted in this case. Then the plaintiffs here, Nagr, sought their first emergency application up in front of the Supreme Court. What this means is that the plaintiffs in this Nagr case wanted the Supreme Court to step in and find that the district court and also the 7th Circuit should have granted their original request for injunctions in this case. And therefore, they wanted the Supreme Court to issue the injunction on their own. In response to the first emergency application, the Supreme Court denied review and the emergency application request was denied, and so that injunction was denied. Now, on that first review, the docket of the Supreme Court simply states that application for a writ of injunction pending appeal presented to Justice Barrett and by her referred to the court is denied. So the original emergency application was referred to the full court by Justice Barrett, and there were not enough justices on the Supreme Court who thought that they needed to intervene at that time. That really wasn't surprising because traditionally, like I mentioned, the Supreme Court does not like to take on interlocutory issues. They do not like to step in early on these cases. Instead, they prefer final resolution cases, and they will let the lower courts decide and resolve these issues before they step in. So the original emergency application was denied in this case, and then this case had to proceed forward at the 7th Circuit level in front of those 3-judge panel judges. Now, on review, a 3-judge panel in the 7th Circuit upheld the district court's decision, denying the preliminary injunction. So NAGR lost at the federal district court level, and then now they also lost at the 3-judge 7th Circuit level. And in response to that, they filed an appeal up to the en banc panel in the 7th Circuit. And they're asking for the en banc panel in the 7th Circuit to review what the 3-judge panel said, to review what the federal district court, the lower court said, and ultimately decide that an injunction needs to be issued. But in the meantime, because there is that looming registration deadline, the plaintiffs here, NAGR, the organization here, it's a two-way organization. The president is Dudley Brown, if you're interested. But what the organization has decided to do is once again go up to the Supreme Court, file for a second emergency application for the Supreme Court to try to at least get a halt on this law because of that registration deadline. That means that once again, the Supreme Court is being asked to step in on an emergency basis to put at least a temporary halt on the Illinois PIC Act. This emergency application was submitted to Justice Barrett because she is the one responsible for the area here. Every justice is responsible for a specific circuit court. And the interesting thing, once again, is that she has requested that the city of Naperville and then also the state of Illinois respond to this emergency application. Now, the three questions presented to the Supreme Court in this new emergency application is first, is the state of Illinois' absolute ban of certain handguns constitutional in light of the holding in DC v. Heller that handgun bans are categorically unconstitutional? Second, is the in common use test announced in DC v. Heller hopelessly circular and therefore unworkable? This question here, which they're referencing in the second part of this, is directly a result of what the 7th Circuit panel stated in their decision, where they said that Heller is circular, that the common use test is not workable, so they decided to not follow Supreme Court precedent and just come up with their own test. And the last question they ask is, can the government ban the sale, purchase, and possession of certain semi-automatic firearms and firearms magazines, tens of millions of which are possessed by law-abiding Americans for lawful purposes, when there's no analogs or analogous historical bans as required by DC v. Heller, and then also New York State Rifle and Pistol Association versus Bruin. So this petition pushes for some really important questions to in fact be answered by the US Supreme Court. NAGR argues in the emergency application that the 7th Circuit completely just botched the Heller and Bruin analysis to essentially just meet their own goal of upholding this rifle and magazine ban. They also point out that the 7th Circuit argued that the in common use test is circular, and therefore they rejected what the Supreme Court said in Heller and Bruin, and they just kind of did their own thing. NAGR states on this point that the 7th Circuit is also not a fan of the common use test and expressed its disapproval using the same machine gun example used by Justice Breyer in his Heller dissent. Like Justice Breyer, the 7th Circuit believes the test is the product of faulty circular reasoning. Accordingly, the court rejected the common use test and implicitly, if not expressly, adopted Justice Breyer's dissent in its stead. So there, NAGR is pointing out to the Supreme Court that the 7th Circuit 3-judge panel here has not adhered at all to what Bruin, to what Heller has said about these firearms that are in common use for lawful purposes, and once again, they're just defying what the Supreme Court has said in their precedent. Now, in response to this emergency application, Justice Barrett has once again requested responses from Illinois and the city of Naperville. This is a kind of a good sign, but not a true indicator of what the Supreme Court will do if they're going to step in. Remember, during the last emergency application, Justice Barrett did the same thing, but ultimately on submission to the full court, because she could have taken it herself, but oftentimes what they do is they refer it to the full court, and the full court on review denied that first emergency application. There was not enough judges who were interested in stepping in at that time. So this is something that is positive that this is happening once again, but we're going to have to wait and see how this plays out. The state's response is due on December 6th. And then right now, the hope is that some form of temporary relief will be granted by the Supreme Court, at least until, or at least before that registration deadline hits, because a lot of people in Illinois are not going to register, they're not complying, and so a lot of people are going to be at risk. But even if the Supreme Court grants the emergency application and steps in right now, remember this would only amount to a temporary injunction that would remain in place and would just keep the status quo until the en banc panel in the 7th Circuit rules in this case. Of course, any Supreme Court finding on something like this, on a finding of likelihood of success on the merits, or if they find that there was an error by the 3-judge panel in the 7th Circuit or the lower court, that would be huge. Either of those types of findings would be a fatal blow to the state of Illinois' law. So we're crossing our fingers right now. Stay tuned to the channel because if anything else develops, of course, I will let you guys know. Make sure you have all notifications on. But again, I want to temper expectations right now because remember, an emergency application has been filed in this case before on similar issues. It was denied already once by the Supreme Court, But the hope potentially is because of this looming registration deadline and some of the decisions by the 7th Circuit and the lower courts, their failure to faithfully apply what the Supreme Court said in Heller and Bruin, maybe finally the Supreme Court will decide to step in. But again, we don't know. If I get any more information, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and a signal to YouTube that you guys see value in these videos and in this type of 2A news. But regardless, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.